We've discussed in our past video the latest decision of the European Union Article 29 Working Party on Cloud Computing. Are there any peculiarities for the Italian market? The opinion of the Working Party is in fact substantially in line with the prior guidelines that had been issued by the Italian Data Protection Authority, although the Italian guidelines were less exhaustive. The Working Party confirms that the cloud services may be commissioned to sub-processors on the basis of the customer's consent, being understood that such consent may also be a general consent. In this respect, the cloud providers should inform their customers about the sub-processors they use. They should inform the customers also about the location and provide other relevant information and any update in case of change of such information. Such update may also be carried out, for instance, through digital registers. Sub-processing may, however, be critical from an Italian law perspective. Under Italian law, any sub-processor should be appointed directly by the data controller, and it could not be appointed by the processor. There are some solutions, but there's still some ambiguity and there's no legal certainty. This means that for an Italian client, it's still advisable to appoint directly each sub-processor. This may be very complicated, particularly with a cloud provider that makes use of a large number of sub-processors. The opinion is also in line with the general trend. See the latest regulation published in January of making the data processors more responsible. For instance, under the opinion, a data processor that acts not in line with instructions of the data controller may be considered directly as a controller and be directly responsible. This position may well ignite a debate in Italy and also beyond the scope of the cloud services. In addition, under Italian law, there is a strict obligation for the controller to make sure that the activities carried out by the processors are in compliance with the applicable laws. This means that in the case of cloud services, the data controller, the client, will have to verify how the activities are carried out in multiple jurisdictions. This may be well difficult for all such remote services. There is no certainty, neither from the European Union position nor from the Italian authorities on how, in fact, such control will have to be practically made. Last but not least, the Working Party opinion addressed also the applicable law issue, in the sense that the law applicable to the service provider may also be extended to non-EU customers. This may in fact be detrimental for such operators that act within a jurisdiction with much stricter regulations for data protection, like for instance the Italian jurisdiction. Perhaps it might be considered mitigate this economic detrimental effect through provisions that provide for the supplier to make sure that it implements all the instructions of the customer and, of course, complies with the minimum security measures as provided by the Italian law. In any event, both on a European Union level and on an Italian level, the strategy adopted by the authorities is very clear. For all such operators that fail to comply and adhere to the new provisions, there may be substantial risks. Substantial risks for cloud providers to lose substantial market share within the European Union. At the same time, the customers may well risk incurring in responsibilities, also on behalf of the supplier. These issues may be addressed also through ad hoc agreements. Please let me know your view. Thank you.